Hello everyone, this is Tom Fox. Welcome to This Week in FCPA, Episode 67 for the week ending September 8, 2017, the post-HARVEY edition. After a 2-week absence, Jay and I returned for a wide-ranging discussion of some of the compliance and ethics stories which happened while we were off and over the last week, including a retired U.S. Army colonel was caught in an FCPA sting. Sam Rubenfeld reported the story, and Richard Bestrong talked about how the arrest of the retired Army colonel, Joseph Baptiste, was unlike the gun sting case where he was a cooperating witness. Andy Spalding asked if the DOJ pilot program could be made even better. We take a look at a New York banker, Mahmoud Thiam, who was jailed for 7 years for accepting bribes from Chinese companies. We take a look at Wells Fargo, whose woes grew even more worser. We speak about Mike Volkov's 2-part series on the intersection of antitrust compliance and anti-corruption compliance. We take a look at a very interesting piece by Bill Steinman in the FCPA Blog about why we fight graft and corruption on an international basis. And we take a deep dive into a Compliance Week pro and con argument over SEC no-admission settlements. For the pro side, we have Brad Karp. For the con side, Judge Jed Rakoff. We take a look at a recent initiative by the Serious Fraud Office in England to have greater powers to fight money laundering. We look at the FCPA investigation of Uber. We talk about my interview of Adam Turtletaub in the podcast FCPA Compliance Report, episode 347, where he previews the upcoming 2017 SCCE Compliance and Ethics Institute. We take a look at some of the compliance lessons from Hurricane Harvey. I rag on Jay for the Boston Red Sox being yet another Boston sports team caught cheating. And we conclude with a short discussion of this month's podcast series of 1 month to a more effective compliance program, where I take a look at innovations for your compliance program. The topics that we've gone over in the first week are strategic plan for innovation in your compliance program, artificial intelligence as a compliance advantage, how to find patterns in rake leaves, and Comtech. Oversight Systems is this month's sponsors. This is a longer episode coming in at about an hour, so I hope you enjoy the length. I hope you enjoy the topics. Jay and I certainly enjoyed being back on the air with you. This is Tom Fox. This Week in FCPA is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, the Compliance Evangelist. I am back with Mr. Monitors, Jay Rosen, and we are back on the air for This Week in FCPA, Episode 67 for the week ending September 8th, the post-HARVEY edition. Jay, we've been off air for a couple of weeks, so a big welcome back from Houston, Texas.
And good to have you back, and good to hear that you and your house and your family and your dogs are all safe.
Well, thank you very much. We've been gone quite a while from the air, but that has not stopped the FCPA and greater compliance ethics world from moving forward. So maybe we could just jump right into some of the bigger cases that we've identified here to talk about, Jay.
Let's do it.
So we had a FCPA individual arrest case come up this week when, or maybe not this week, certainly in late August, when there was a unsealed indictment, and it was a rare FCPA individual enforcement action, Jay, because it involved an sting operation. And the unsealed criminal indictment of Joseph Baptiste, a retired U.S. Army colonel who was charged in Massachusetts with conspiracy to violate the FCPA, money laundering, and other nefarious things, where a undercover FBI agent was paid money, gave money to Baptiste, who would then use that to pay bribes to obtain business from Haitian government officials in the country of Haiti. So it's very unusual to have a sting operation in an FCPA case. Sam Rubenfeld broke the story in the Risk and Compliance Journal, and he noted that this was only the third time in 40 years that sting operation had been used in a foreign bribery case. In his piece, he talks about some of the reasons why, but I think most people remember the Gunstein case and how that ended. A couple of interesting points on this one. The first was that Baptiste solicited bribes from undercover FBI agents in Boston, posing as potential investors.
And where did that happen? Illegal activity in Boston? I'm shocked.
Yes. It was not even a Boston sports team. So, it's going out to the wider non-sports community. Anyway, they were posing as potential investors in infrastructure projects in Haiti, including a port project at the center of the case. He was caught on phone calls intercepted under a court-ordered wiretap discussing the bribery of an aide to an Haitian government official who had part of the job around that port development project. And the FBI agent sent Baptiste $50,000, and he ended up using that money on personal expenses, not to bribe the foreign government official. But he was going to use more money from the FBI to pay future bribes out. And then another interesting twist, Baptiste had agreed to plead guilty in December 2015, but more recently had decided not to honor that agreement. So that's really unusual, where somebody would agree to plead guilty and then turn around and say, no, I want to go to trial. You would think that they would have considered their position and considered that perhaps they didn't really have a defense, but his lawyer says that they're going to put up a defense at trial and see how it goes. So maybe the DOJ wanted a stiffer sentence and they were willing to agree to. Who knows the reason? And then the timeline on that, 2015, and here we are in the middle of 2017. That's certainly a fairly long time for all this to happen or not happen, as the case may be. So really interesting development there. And then if I could maybe take a minute to contrast, or at least Richard Bestrong, I wrote what I thought was a very interesting piece in the FCPA blog entitled The Baptiste Case Isn't Another Africa Sting Case. And, perhaps I'll give him a grammatical pass for putting a contraction in the title of a professional article. But he talked about the differences between this case and his case, really the Gunstein case. And in the Gunstein case, he was an undercover cooperating witness in that matter, although that did have some stings around it because it was a fake operation, a fake bribery opportunity, where this case was not a fake bribery opportunity. But Bestrong went on to talk about some of the other cases where undercover operations were used, and obviously Joseph Siegelman, the former chief executive officer of Petro Tiger, when the FBI wired up his lawyer when he went to talk to him. And then Bestrong had a really interesting line which said, all stings are undercover, but not all undercover operations are stings. So he said procedurally, or perhaps evidentiarily, the absence of a cooperating witness dramatically reduces the testimony from a person who may have past or concurrent criminal conduct, which would cause him to have a brutal cross-examination. So here we have court-ordered wiretaps, and Bestrong believes that will be more favorably viewed upon by the potential trier of fact, whether that be a judge or jury. So, and then Richard ends his piece really with something from his trial where he was at least aggressively cross-examined on why he never used the word bribe in his conversations. And in his piece, he said, for several evidentiary reasons, I couldn't share those details in the courtroom, whatever that might mean, whether there was an objection and it was sustained or some motion in limine, which keeps certain evidence out. But he says, I share the evidentiary reasons now, especially when addressing compliance in commercial terms. And he says, quote, it's because people don't say bribe. And, he tries to make that a dramatic point, and perhaps it should be, but it's really not dramatic. And it's the way people talk about illegal conduct in business. Even if there was organized crime in Boston, they probably wouldn't talk about use the word bribe, or any other city in the Northeast. They would use some other word, some code word. That's the reason, and I think Richard's spot on that point as well. So, kind of, what were your thoughts on all of this?
Well, I think it's a pretty interesting situation, and I too enjoyed Richard's piece because he really informs it from a perspective of somebody who's going through it. And another point that I kind of took away, and I'm not sure if it was from the original article or Richard's article, but it seems that since Richard had to take the stand and a lot of focus was put on, whether or not he was being accurate and, how he presented himself in court, it seems with the Baptiste case that there's more analytical information to go on, the wiretaps, and less things that could be pejoratively impeached. So that was the takeaway I took. To your point, I still think it's pretty interesting that after a year and a half, he's decided to, shake the dice and see what happens. So I'm wondering what has happened in the intervening 18 months. It seems like, from the Wall Street Journal article, from what Sam wrote, that this might be something that came of the augmentation of the FBI strike force with more people in New York, LA, and DC. So this kind of does show you it takes a while to develop a case. And I'm wondering whether or not this could be a trend. I guess, number one, it's going to depend upon whether or not there's going to be a conviction. But if they are successful in doing this, maybe there are other cases that are going to be made using more of the traditional investigative techniques that the FBI is so good at.
Next up, we had an article by Andy Spalding, Professor Andy Spalding. I think he's at the University of Richmond, in the FCPA blog, entitled, "How Can We Make the Pilot Program Even Better?" And it looks like Andy is going to have a several piece series on this. And he's got a paper coming out that is linked to in the FCPA blog piece. And of course, we're linking to the FCPA blog piece in our show notes. And it's going to start, I think, an interesting review of the pilot program. Today, someone else kind of wrote or put up an article where they severely criticized the pilot program, but that's not the perspective Andy Spalding has. And he starts off with, I think, a pretty good review of the four prongs of the pilot program, and that's where he seems to be going. So let me just quote, although the guidance, the pilot program guidance, as opposed to other guidance, is widely understood to impose three factors: self-disclosure, cooperation, and remediation, there is actually a fourth. It is not numbered and does not appear in the same section as disclosure, cooperation, and remediation. It precedes them and is buried in a prefatory language of page 2. The pilot program provides that to be eligible for the credit detailed in the memo, even a company that meets the three prongs will be required to disgorge all profits resulting from the FCPA violation. So we've now seen two examples, Jay, earlier this year, of declinations with disgorgement. Andy finds this to be something that advances the underlying purposes of the FCPA and enforcement of the FCPA, and I certainly tend to agree with him. It's going to be interesting to see how this plays out going forward, and he's a great writer, he's a great professor, great lecturer, great speaker, so I'll be very interested to see, and perhaps we can have some follow-up on future episodes. So next we had a conviction of a banker, for a U.S. citizen actually, for soliciting of bribes. And in kind of a twist. We have a New York banker who at one point was a mining minister for the West African country of Guinea. And he was the mining minister for Guinea, although he was a U.S. citizen, because he immigrated to America as a young lad, no doubt as a dreamer. And he obtained U.S. citizenship. And then in from 2009 and 2010, he was the Minister of Mines and Geology in Guinea. And he took $8.5 million in bribes from the Chinese company Sonangol International to give them mining rights. And he was convicted of that in a court in New York. I think he was sentenced to 7 years. 7 years in jail. And he was convicted for money laundering, although this is not an FCPA case because the person who actually received the money was a U.S. citizen, and he was indicted under money laundering laws. I suppose it's possible that the Chinese involved could have been at least indicted. I doubt they could have been brought to justice. But a rare case where we have a U.S. citizen who's serving as a foreign minister of a foreign country, convicted of receiving bribes and money laundering.
And importantly, he says during his trial, he lied to the banks not to conceal bribes, but to avoid being designated as a PEP, a politically exposed person. His primary concern was to be treated as Mahmoud Thiam, private citizen, he testified. And as we all know, banks are sometimes reluctant to deal with PEPs because of money laundering concerns, and they would have been right on in this matter.
And you've always wondered why Bruce Wayne did not want to be known as Batman. Well, now you know. He just wanted to be regular old Bruce Wayne.
There you have it. So now we have another story that just will not go away. Wells Fargo, based on another internal investigation, has now boosted the number of unauthorized accounts to 3.5 million. So in the first go-around, they had admitted to 2.1 million. And in this new round of exploration, they came out with an additional 1.4 million fraudulent accounts. So depending on whose numbers you want to do, they either added an additional 40% if you look at the whole thing as 3.6 million accounts, or based on the original 2.1 million, they've added or uncovered 70% more of fraudulent accounts. So this is the Corruption Institute that will just not go away. This case has been going on for the last several years, and it looks like, despite paying the fines and saying that they're remediating and do everything that needs to be done to come up with a number of accounts that is, more than almost 3/4 of what was not initially accounted for. It really means that there's still a lot of work to be done within Wells Fargo.
And this is on top of, I think it was 500,000 people who were found to have been assessed illegal insurance charges or other charges that the bank shouldn't have put on. So it's really just quite astounding. Jay, Warren Buffett called it, and he said the following: whenever you find what you find is there's never just one cockroach in the kitchen when you start looking around. And you're right. This is the case that just the company just keeps on giving. And to have an increase of 70% in the number of fraudulent accounts is almost mind-boggling. It puts into question the internal investigation done by Wells Fargo. It puts into question the external investigation by outside counsel. It certainly puts into question the testimony by the former CEO when he made to Congress, all of the disclosures. I don't know if you bank at Wells Fargo, but I would have to say I'm not going to bank at Wells Fargo. And that's really the bottom line when you have a bank that can't be trusted. That's really what a bank has, is trust. And the what I really speculate on is the following, Jay. You and I both know the most dreaded question in the FCPA world is where else? Because that can lead literally to a worldwide investigation. And you've seen that, from your former days as Mr. Translations right up and through your current days as Mr. Monitors. But Wells Fargo may add a new question, which is what else? Because this is not international, this is all domestic. And putting on another 1.7 million unauthorized accounts on the 2.1 already, this is just, like you said, almost mind-boggling.
So if we follow your go down the rabbit hole of what else, do we go back into mortgages, or do we go into private wealth, or where would you think the next area of trouble may lie?
Well, private wealth is probably going to be smaller in numbers, simply because there's less wealthily private people than those who have regular accounts at Wells Fargo. But certainly you're absolutely right on mortgages. Another huge money maker for the company. And if they, I would have to assume they haven't charged usurious interest rates, but they surely could have, if they were putting insurance requirements on auto loans, if they're putting those kinds of charges on regular account holders, they could be putting illegal, unethical, or other charges on mortgage holders, and mortgage holders not even be aware of it. So it could certainly continue to expand. I did a fairly passionate podcast on Wells Fargo, the Wells Fargo board, asking them to put someone from compliance on the board because they've got to get some compliance and ethics inculcated in this company, and they obviously didn't have it. The timeline they're looking at for these accounts was back to 2009, but what happens if they start looking further back? Is that going to be another, X million? And it is just bad, and it keeps getting worse.
All right, well, let's jump over to one of the contributors to the Everything Compliance podcast, our good friend Mike Volkov. And you've selected a really great two-part series that Mike put together, and it's about how chief compliance officers have to not only address corruption risks, but also look at antitrust risks. So what was it about this article that caught your eye, Tom?
So really what I want our audience to understand, Jay, is that there is a convergence of compliance. Compliance can be anti-corruption compliance, the compliance you and I have focused on for the last few years, but compliance is really following any regulatory scheme. So you can have export control compliance, you can have anti-money laundering compliance, and you can have antitrust compliance. And Mike has an antitrust background. He was actually in the DOJ antitrust section, so he can speak to the specifics of antitrust much better than you and I. But the point I took away was that antitrust compliance should be a part of the chief compliance officer's remit, because the dangers for antitrust violations are actually greater under the Sherman Antitrust Act than under the FCPA, and that companies need to have a robust anti-corruption compliance program similar to an antitrust compliance program, similar to an anti-corruption compliance program, and that if you don't, you are setting yourself up that, once again, if the DOJ comes knocking and you don't have an antitrust compliance program, then you have nothing to try to trade your sentence down, or trade your fine down. Most companies, and maybe you can think about your corporate experience here, most companies mention antitrust in a code of conduct or code of business ethics, something like that, at a very high level, and they say don't engage in, don't talk to our competitors, that kind of thing. In my corporate experience, we had a little more training in the legal department than that, but that was really it. And that was the antitrust compliance program, was just training. And so I think companies need to take a pretty serious look at this. They need to see if they have assessed their risks and then manage that risk. And Mike really lays out, I think, two pretty good blog posts how to do so.
Yeah, I think it was one of the things I appreciate with Mike is that he is really able to get right into the meat and really write blogs that can be immediately prescriptive on what you need to do. And, I think to a certain extent, a lot of these things that you're looking for, there is some overlap with FCPA. But I think if you're doing the compliance on your business, these are things that should additionally be on your radar, and Mike really brings up some good points as to what to look for. Next up on our list, we've got an article by Bill Steinman on graft, and he's entitled it, Why We Fight. And with you being a film buff, do you want to launch off there and tell us where Bill gets the title from and what he discusses in his piece?
Sure. In connection with World War II, Frank Capra was asked by the U.S. government to put together a film series, really propaganda films, but films nonetheless, on why the United States entered World War II and fought World War II. If you have not seen these, they are fabulous movies. Frank Capra, obviously a great director, and he did first-class movies. And in the series, he examined why the U.S. needed to join and stay in the fight against fascism and stand up for what is right. So Bill really took a riff on that, and I thought just in an excellent piece. If you know Bill at all, he's a great speaker and a great writer, and a good friend of, I think, both of us. He talked about graft and corruption, where in my mind the two are equal, across the globe, and the true cost. And he talks about it in terms of natural disasters. He talks about it in terms of healthcare. He talks about it in terms of undermining market forces. He talks about, as a business traveler, he wonders whether or not a civilian aviation authority in a country he may travel to has been paid bribes. He worries about fire alarms in hotels, substandard underground travel systems. He talks about building collapses. He talks about things like WorldCom and Enron, which were financial fraud. And he really lays out, I thought, an excellent reason. I've written about this, and Bill takes, I think, a fresh look at it, and it very importantly articulates why the United States, it's in the specific interest of the United States to engage in the worldwide fight against corruption. There are some commentators that say it's not in the interest of the U.S. We can police U.S. companies, but that is it. Well, that view is wrong, and it's wrong for many reasons. But Bill points out the human cost in that, and I really thought it was a great piece and something that everybody should read, and every chief compliance officer needs to be aware of going forward.
Yeah, I think it can kind of give some strong background to what General Mathis was speaking about a couple of weeks ago.
Yes.
And it really does, like you said, make the case for why we all do what we do. Next thing, we've got almost like what would you call it? Like a little mock trial debate dealing with the terms neither admit nor deny. And on the for side, we have Brad Karp from the law firm of Paul Hastings, and he's assisted with his colleague Susanna, I hope I don't butcher her last name, Burgell. And then on the against side, playing contrarian again, is the Honorable Judge Jed Rakoff. So Tom, why don't you tell us about neither admit nor deny and why that is on the arguing table here between these two parties.
Sure, and I'm going to really geek out here, so you just have to bear with me. So this neither admit or deny are types of settlements generally entered into by regulatory agencies. This is not the Department of Justice. This is Securities and Exchange Commission that we're talking about specifically here. And they've been a feature of regulatory enforcement for some 50 years. They've come under, if not withering criticism, certainly significant criticism. Judge Jed Rakoff has led this criticism of neither admit nor deny. And let me start with Judge Rakoff's criticism. He believes that the purpose of SEC enforcement in securities fraud is to maximize the deterrent effect, and that the argument of the for or pro admit or deny language to conserve resources, allowing corporations to not spend money on an expensive trial, and to protect them from secondary or follow-on actions such as shareholder derivative suits, is not a valid argument because the purpose of enforcement is to deter. And he believes it would be a far better use of SEC resources to actually take companies to trial than to obtain meaningless settlements. From a judicial perspective, he also says that admit or deny settlements prevent many cutting-edge legal issues from ever being decided and develop and inhibits the development of law. And really, in perhaps his most withering comment, he concludes by noting that by allowing a company to neither admit nor deny is the notion that one should be able to avoid compensating the victims of one's fraud, i.e. the shareholders or others who might sue, by denying misconduct that a company would otherwise be prepared to honestly admit to the SEC sounds hypocritical, if not downright honest. Karp and we decided her name was Burgle.
Did you mean dishonest?
Dishonest, right. So
okay, thanks.
In the for or pro, they really say it's in the interest of the SEC to allow corporate defendants to avoid making admissions that will be used against them in parallel civil litigation, and that if the SEC didn't do this, the cost, even if you just consider the cost of the fine and penalty, would really pale besides the entire cost that a company would pay. He worries about employees losing jobs, creditors getting paid, commercial counterparties being able to enforce their contract rights, and that corporations cannot effectively defend a follow-on civil litigation if they've been forced to make material admissions as the price of a regulatory settlement. So it's really competing interests here. A corporation wants to get out for as little as possible, money-wise certainly, but they also want to not admit any facts. And interestingly, Karp points out, and once again correctly points out, that there have been two instances where federal judges have not granted admit or deny settlements. And in both cases, the courts of appeals overturned the federal district judge and said they committed reversible error in not admitting the proposed cease and desist orders, which had the admit or deny language in them. So when you consider the regulatory framework that's been in place for 50 years, this seems to be, and certainly in Karp's mind, working. Judge Rakoff's response to that is simply that a past persistence of a flawed policy is no reason to continue using it. So this debate will continue. I don't know if Congress would have to get involved to change it. Perhaps so, because it's pretty clear from the court rulings that federal judges cannot reject an SEC settlement which uses admit or deny language. And we found out this year that federal judges cannot reject a deferred prosecution agreement because they believe it is too lenient. So lots of power to the prosecutors, whether those prosecutors be at the DOJ or the SEC. if you enjoy getting into the weeds, I would heartily commend you to these two articles in Compliance Week. Once again, we'll link to them in the show notes. So for all you lawyers out there, geek out.
And anything in light of these articles to relate back to our favorite book of the late summer and early fall, the Chicken Shit Club?
Well, certainly on the DOJ side, deferred prosecution agreements, but as Karp correctly points out, neither admit nor deny settlements have been in the SEC's bandwidth for 50 years. So that is not new. What the Chicken Shit Club, I think, really focused on was the lack of criminal prosecutions involving the financial crisis and what led to that. So to the extent federal judges do not have any say-so over deferred prosecution agreements, I would say the answer is yes. To the extent that this specifically relates only to the SEC, probably not.
Okay. Next up, UK seeks tougher laws on corporate financial crime.
Yeah, we wanted to bring in an international flavor to this week. So we've got a piece from Susie Ring, and I think this was out of Bloomberg, where she said that there's a proposal in the United Kingdom to make it easier to hold companies accountable for financial crimes, and it's failing to prevent financial crimes. Now, under the UK Bribery Act, there is an action against companies for failing to prevent bribery, but this is broader. This is money laundering and other financial crimes. And if the UK passes this, it could really put the onus on companies to take much more aggressive and affirmative steps to actually prevent bribery and corruption and other financial crimes. And this could be something that could cross the Atlantic. So I wanted to raise this, Jay, to alert the international compliance practitioner who might be listening in our audience, but also to think about what would be the impact on your company if this came across the Atlantic in some sort of new legislation. So interesting development, which we will follow.
Great. Now, you and I have taken many of an Uber to dinners at conferences and baseball games. Are we going to have to switch our allegiance, or what are we going to do now that Uber has announced that they are under FCPA investigations?
Well, Sam, no. Two other reporters from the Wall Street Journal in the tech section, Douglas McMillan and Aruna Viswanathan, broke the story that Uber is under investigation by the Department of Justice for FCPA violations. And I have to start out, Jay, by saying it's really no surprise. I can't say I'm surprised, given the company's lack of an ethical culture to start with. It would not surprise me at all. And from the lessons learned, and perhaps this would be the subject for another podcast, but really, Uber is a company that everything they do touches a foreign government or a regulator, because the taxi cab industry is one of the most heavily regulated industries literally across the globe. Taxi cab drivers from Houston to London to Sichuan have to have some sort of government permit. So the individual driver has to have a permit. You have to have a permit to put your cab service on the public roads. There's a safety requirements for car inspections. Just almost every touch point you can think of, Uber has that with a regulator in some country, in some state, in some city, and maybe in some county, some places. So given what we now know about the toxic culture at Uber and their complete lack of ethical values, at least before the resignation of former CEO Kalanick, I'm not surprised. It wouldn't surprise me at all if Uber was greasing payments, making grease payments, or greasing skin, as we would say, not bribes, just a little grease here and there to make things lubricate better. But whether they'll claim they were simply facilitation payments or not, they may make that argument. But it doesn't surprise me at all. And of all of the headaches that the new CEO has, this may be one that bubbles up for him quite a bit too.
All right. Well, that remains to be seen. Here's something that you and I were talking about before we went on the air, and just about 6 weeks away now is the SCCE, the Society of Corporate and Compliance Ethics, Compliance and Ethics Institute, which will be held in Las Vegas this year from October 15th to the 18th. And Tom and Adam Turteltaub had a great conversation, and they're really taking a look at how to plan your conference going experience. What is the best way to attack meeting a couple thousand of your newest best friends? And Tom and I have been going to the conference for a while. So Tom, what were some of the thoughts that you and Adam came up with about the best way to get the most you can of the upcoming CEI?
Well, Adam really had about three things that I think he highlighted. One was the various tracks, and these include the following tracks: ethics, risk, case studies, compliance lawyer, multinational, international, IT compliance, general compliance, hot topics, and advanced discussion groups. So kind of point one is get the schedule, get the brochure, plan out the track you want to attend, and get to kind of plan out who you want to hear and what you want to see. The second is take advantage of the non-breakout sessions and non-keynotes, meaning the Sunday beforehand, where speed networking and speed mentoring. Take advantage of the cocktail party reception on Monday night, I think. Wear your jersey. Everybody wears a sports jersey, and you get to kind of either talk to or rag on people about the teams they're supporting. And then talk to the vendors. Get into the vendor room. Go around and see what are some of the innovations. A lot of companies have innovations or new product offerings that they will roll out at or near the time of SCCE for maximum exposure, and they talk to them about that. Find out what direction they're going. What's new? Are they vendors there to sell? Absolutely, but they're not going to make you sign up, and they're not going to make you give your, you got to show your ID to give them your detailed information so they can follow up. They're not going to take all of that contact information. So if they want to talk to you, and they want to talk to you in an informal atmosphere, and frankly, a very friendly atmosphere, it's not a hard sell. It's information, and they're going to have a lot of information at their booths, which they can share with you. So really, those were kind of the three takeaways I got from Adam. We're expecting nearly 2,000 this year, I think he said. It's going to be huge. We're going to be in the Las Vegas Caesars Palace. I've stayed there before. It's a fabulous venue and well set up for our size group. So looking forward to doing it this year, Jay.
Great. Here's a couple things that I just wanted to tack on. To your point about making the most out of the non-official sessions, one of the things that I've been doing for the last 5 years is showing up early on the Saturday before and being part of the volunteer event. And for 3 of these conferences, it's been pretty easy because I'm in LA and I can just hop a jet to Burbank and be there in about an hour. But in Vegas, we've worked at a local food bank putting together bags for people who need food. A couple of years in a row, we worked at a local veterans house where we did some yard work and some gardening and repainting. And we also did similar events in Chicago. So the first time I ever went to a CEI, I didn't know anybody, and I figured the best way to go about this was to optimize the chance I was going to run into people. And the nice part when you're at the volunteer session is everybody has a name tag on it, but it just says your first name. So, as the conference went on, I realized that I was sweating next to Al Gagné or working with Dan Roach and his wife, and I really had an opportunity to meet a microcosm of the people who have been very meaningfully involved with SCCE. Al's a very good friend. He's been instrumental in getting me to participate in the advanced discussion groups. So that's one thing. And the second point I want to echo from Tom is that we go to a lot of conferences during the year, And SCCE is one of the most popularly priced conferences that it doesn't really break the bank, and you get a lot of content and you get a lot of contacts. The other thing is they set up a friendly environment where you get to interact with the vendors. And I think, as Roy and Adam usually say, the new advances in corruption are going to, and anti-corruption and ethics and compliance are going to come from all those vendors who are in the conference room and who are there by, where you get breakfast and where you get coffee. But the SCC really believes that that's where innovation comes from. And unlike some other conferences where they kind of stick the vendors in the back so they won't bother anyone, I've made a lot of friends in the vendor community. I'm part of it, but I would highly recommend both those things to really help and enhance your conference going experience. Tom, we're now going to come up to a couple things that you wrote about, some personal experiences with the hurricane and what they've made you think about from an ethics and compliance readiness perspective.
But there's really two things that I wanted to highlight. The first is that you have to be prepared. You have to be prepared for an emergency. You've got to have a preparedness plan in place. And living here in Houston, you would think that companies would have a hurricane preparedness plan in place. If you're doing business internationally, you would hope that you would have an FCPA preparedness plan in place. But the other thing, Jay, that struck me as I worked through those issues through the week, that I ended the week with, is you have to practice your preparation and you have to practice compliance. And I cited back to the James Mattis memo where he talked about the ethical considerations and actions of Department of Defense and U.S. military members. And he said in there that we would practice our ethics so that when the situation came, we would either know what the answer was or we would have that so wired into our system that we would just do the right thing. So really practicing compliance, I think, is going to be the lesson that I really take away from it. Obviously, I wrote and thought a lot about Hurricane Harvey, but there were some other great commentators who wrote that I've cited to. I'd like to just shout out to Jacqueline Jaeger, discussed in corporate philanthropy at its finest in an article in Compliance Week. Matt Kelly wrote about some of the best and worst of corporate actions and behaviors in his post on radical compliance. And then Matt and I took a deep dive into it on our podcast, Compliance into the Weeds. So lots about Harvey. I hope you'll take a look at some of those still impacting Houston. And if I could ask on a personal note, please make some donation to the charity of your choice to help the people. A lot of people are suffering here. But from Hurricane Harvey to cheating in Boston, what could be better about Beantown than cheating? So
yeah, this was the part of the podcast that I dreaded.
Yeah,
I was hoping we could spend as much time away, but I'm sitting here. Why don't you unload on me and give me the signs?
So at first I thought, oh, how horrible this is, but this is baseball, and in baseball, stealing signs from a catcher is not only an age-old, but it's an honored tradition. And the first recorded instance of stealing of signs from a catcher in baseball, I think, was 1867. So we have conduct that's been engaged in for nearly 160 years here. What the Red Sox did that's got people so excised is they use technology. Well, I'm not going to break our, I'll just say boo-hoo. They use technology. Binoculars are technology. Signaling in from center field on a buzzer is technology. Now, it's not technology if you're standing on second base and you can see the catcher. I acknowledge that. But it's pretty close to technology if you use hand signs to signal to your batter what the next pitch is. So, Jay, this is really all much ado about nothing. And if your Patriots weren't such well-known and convicted cheaters, nobody'd care.
Well, Tom, you were much softer on me than I thought you would be. But, baseball does have its traditions, and what do they call it? Brinksmanship is one of them. But I'm going to choose to take the other side here, and I'm like, come on, guys. You're well paid, you're pampered, you're treated well, and you've got skills. So I don't know how many extra wins above replacement you're going to get from using your Apple Watches. So I think I'm just feeling the toll of everything from Deflategate and Spygate. I'm just wondering, what do the Bruins and the Celtics need to do to join the club? Because what are you going to do in ice hockey? How are you going to use technology to score a goal? And then in terms of the NBA, are we going to see some type of variation on Deflategate? So any predictions on how the rest of the Boston sports teams can join the club?
I don't have a prediction, but I guess the one thing that really does bother me about this is the use of the Apple Watch. And I just hope that the Apple brand is not tarnished because of its association with the Boston Red Sox. Well,
I guess if I'll leave it at that. So we are now in a new month. What are you looking at this month in your 1 month to a better and more effective series? What is the topic?
So, Jay, this month I'm reviewing innovations for your compliance program. We posted on day 4 today, but this week I've looked at having a strategic plan for innovation in your compliance program, artificial intelligence as a compliance advantage, finding patterns in rake leaves, and the new term that I coined, ComTech, which is the technological solution to the compliance industry. I've got a new sponsor this month, and that's Oversight Systems. So shout out to Oversight, and thanks for being this month's sponsor. And really have enjoyed this because I've got to talk about a lot of things. I've got the month planned out, Jay. So I hope the listeners will check out my 1 month to a more effective compliance program series. It's been a ton of fun doing it. And I haven't quite figured out how I'm going to extend it into 2018, but through 2017, I will certainly continue it through the end of the year. This month, it's innovation in compliance, and I hope you'll check it out.
And if anybody wanted to get in touch with you to sponsor one of the monthly podcasts, what would be the best way that they should do that?
They can contact me at tfox@tfoxlaw.com. So, Jay,
excellent.
Unfortunately, we're near the end of our time. It's been a great episode to catch up on. It's been great to get back in the saddle with This Week in FCPA, but I was wondering if you might want to take us home.
Sure. So on behalf of Tom Fox, the compliance evangelist who is safe and back at home in Houston where he belongs, and myself, Jay Rosen, Mr. Monitor, we'd like to thank you for joining us on this extended podcast of 1 hour as we've caught up for last week, and we've looked at the FCPA week that was for the week ending September 8th, 2017. Thanks for listening, and Houston strong.
This is Tom Fox again. I'd like to thank you for listening to this episode of This Week in FCPA. If you have listened to this podcast on iTunes, we would greatly appreciate it if you would rate our podcast, as it would help in our rankings and help get the word out about the only weekly wrap-up of all things compliance and ethics related in the podcast world. Also, if you have any questions, you can contact me at tfox@tfoxlaw.com. You can contact Jay at jrosen@affiliatedmonitors.com. Thanks again for listening. This Week in FCPA is a part of the Compliance Podcast Network.